All right, I saw the Vatusa stuff, and I'm also getting a lot of questions about what would what have potentially been enough for Judge Lyman when he says there wasn't any evidence of crime fraud. And they're both kind of on the same issue, so I'm going to try to cover them both at once. So evidence is proof, okay? Evidence is facts, which can exist in all kinds of different mechanisms. It can be testimony, it can be documents, it can be videos, right? Evidence is proof that things have happened. It's proof of facts. The allegations that someone puts in their complaint and the arguments that lawyers make when they're arguing to the court for or against something are not evidence. They are allegations and argument. Those things in and of themselves are not proof. Okay? So when the Wayfarer people tried to establish the crime fraud exception to the attorney-client privilege for Stephanie Jones, what Judge Lyman was saying was, you can tell me that all of this happened, and you can tell me that this whole thing was shady, and you can tell me that this seems wrong. But that's just the lawyers telling me what they think is true. I don't have any proof, right? I don't have an affidavit or a deposition under oath from Blake Lively saying, we filed the New York case for the sole purpose of getting these documents, and then we closed it. You don't have emails from Stephanie Jones to Leslie Sloan saying, we'll drum up a fake case. Will you respond to the subpoena, even though you know you're not supposed to turn that stuff over under Wayfarer's contract, right? That would be proof. That's evidence. And at this stage, Wayfarer didn't have any of that stuff, probably because they're still in discovery. And Lyman said, I'm not going to pierce through attorney-client privilege simply because the lawyers have said, hey, this thing happened and we think it was weird. They need proof. Now, yes, Jen Abel has made allegations in her complaint that substantiate some of this weirdness. But again, allegations in a complaint are not proof. And the argument that Brian Friedman and Mitch Schuster and Kevin Fritz and all these other people made in their response to the motion for protective order, saying this looks like a crime and a fraud to us, those aren't evidence either. So the point I'm trying to make is that there may be evidence down the line. I imagine when they depose Lively and Jones, they're going to get all into this, and they're going to ask them things like, was the sole purpose for filing that New York case to get these documents? Had you seen those documents? You already knew they existed when you filed this case, right? Why didn't you ever go after any of the other John and Jane Doe defendants in that case? What was the purpose of that? Ms. Jones, did you have conversations before this happened so that you knew this subpoena was coming and you planned to turn over the documents even before you got it? They need to actually prove that through the process that lawyers use to get discovery, to get proof that is reliable so a court can rely on it. Just because a lawyer says it in a document or it's in a complaint doesn't make it true. So that's on the crime fraud thing, on the Stephanie Jones thing. I am certain that we are going to have much more fulsome story of how all of this went down once those two people and whoever else was involved in it are deposed. And at that point, if there is testimony under oath in a deposition, that becomes evidence. And that's where they could try to bring this up again. Now, with Vatusa, remember that Sloan was seeking information from him. He said, no, I don't want to give it. I have the journalist privilege. And they said they were trying to work it out. And it appears that the way they have worked it out is, rather than continue to fight over this issue, he was willing to sign a declaration, which it's just the federal court version of an affidavit. He was willing to sign a declaration to say, when I said that Leslie Sloan told me that Blake Lively was sexually assaulted, I misspoke. Leslie Sloan never said that to me. She said sexually harassed, my mistake. Okay? And that declaration was enough for Leslie Sloan and her lawyers to give up trying to see all of the communications that Vatusa had with all of the different people surrounding that particular issue. Because the declaration to them is evidence, just like all the communications they were asking for would have been evidence. So it looks by Sigurd Macaulay's letter that they have agreed that if he gives him this declaration, which he did, I'm going to look at it in a second, and he turns over the communications directly between Vatusa and Brian Friedman, which many people had brought up because, of course, those aren't covered by any kind of journalism privilege, right? If he'll do those things, then they don't need to see everything else, and they don't have to fight over whether these are protected source documents, because that gives them what they need. So this is evidence that is good enough for them. They know that there are documents out there that they asked for that he's not turning over, but they've decided that they don't need those because this is better. So here's the declaration. It's very short, and he just says, you know, I'm the person, all the things you have to say. There were these text messages. I was referencing this sexual harassment. Leslie Sloan never said to me that Blake Lively was sexually assaulted, and when I said that to a third party, I was mistaken. It's my fault. And then also, Wayfair didn't ask me about that before they put that stuff in a complaint, and that's not cool. Okay? So this is the declaration that he has given. Now, what does Leslie Sloan do with this declaration? One, obviously, she's going to get the documents from between Vatusa and Brian Friedman, so that will make her happy. And she's going to be able to drop, in fact, she already has asked to drop, the motion to compel everything else. Can she use this declaration in her case to try to get herself out of the case? Yes, but not yet. So this declaration has solved the issue for the discovery dispute, but it does not mean that the case is automatically over for Leslie Sloan. And the reason for that is, and listen to me when I say, all evidence is subject to questioning. Just like if you see a text message, you can't assume that's the authentic text message, that they got it from the right place, that it wasn't doctored, that it came from the right phone. All evidence has to be authenticated and tested in order to be used to make a legal decision. You cannot consider a declaration at the motion to dismiss stage. So Leslie Sloan can't use this to attach to her motion to dismiss. She can try to get summary judgment based on it, which is the next opportunity that comes down the line. But this declaration can still be subject to poking and prodding. For example, the Wayfarer people may say, this is a load of horse shit. He's changing his story. He told us in December 2024 that the woman said sexually assaulted, right? Just because he said this under oath doesn't mean no one ever gets to ask him about it again. So they can test this, and Wayfarer will. They will decide whether there is or isn't an issue of fact here. So, in summary, evidence is not things written in complaints, and it is not things that come out of lawyers' mouths. It is information and proof developed, authenticated, and laid a foundation for that comes through the discovery process. However, all evidence is subject to being questioned. No evidence is bulletproof. Hope that helps.